Okay. Ladies and gentlemen, are called to order this hearing of November 14th, 2024 in the matter of Z0218-24. My name is Joe Turner. Excuse me. I'm the hearings officer for the county. My role as the hearings officer is to conduct public hearings and make decisions about certain land use matters in Clackamas County. In making those decisions, I am required to apply the county's existing laws. I'm not a policymaker. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with Board of Commissioners and Planning Commission to do that. But state law requires that this application be judged based on the laws in effect when the application was filed. As a hearings officer, I'm to provide an unbiased decision maker. I believe I am unbiased with regard to the application before me today. I have not had any pre-hearing contact with any of the parties regarding the subject of the application, and I don't have any interest in the subject property or any of the surrounding properties. But anyone has the right to challenge my impartiality, to argue that I'm biased in one way or another, and you can do that when it's your opportunity to testify. Procedure will follow. I'll start by asking staff to summarize their staff report, copies of which are available on the county's website. Then the applicant will have the opportunity to present their proposal and respond to the staff report. If anybody else wants to testify in support of the application, they may do so. And then anybody who wants to testify in opposition or with questions or concerns. That should cover everybody who wants to say something about this application. You'll fall into one of those categories. Once everyone's had an initial opportunity to testify, I will give staff and the applicant alone the opportunity to respond to the testimony that was offered. If those responses include any new evidence, I will give everyone a chance to respond to the new evidence. Otherwise, I'll close the public portion of the hearing and announce what I'm going to do. In most cases, I will issue a written decision within about 2 weeks after the close of the public record. I'll send my decision to the county. The county will send it to parties of record. So anybody who testifies orally or in writing will be sure and receive a copy of my decision. If anybody chooses not to testify but wants to receive a copy of my decision, you can contact staff and they'll put you on the list to make sure you get a copy. But anyone with an interest in this application may offer relevant oral or written testimony. But testimony should be relevant to the applicable approval criteria, which are set out in the staff report. Also, however, it is important that all parties make their best case to me. My decisions are final for purposes of the county, but may be appealed to the Land Use Board of Appeals, or LUBA. However, LUBA generally will not allow new testimony and evidence on appeal. They'll decide any appeal based on the record before me. So if you feel it's important that myself or any future decision maker knows something about this application, you need to make sure it gets into the record before me. In order to preserve your right to appeal, you or someone expressly representing you must testify orally or in writing before the close of the record. And in order to raise an issue on appeal, someone must have raised that issue before me, with enough specificity that everyone can understand what that issue is. And if the applicant wants to object to any conditions of approval on constitutional grounds, they must raise those issues before me as well. If you feel you need more time to prepare, you can ask me to hold the record open or continue the hearing. If I hold the record open, you'll have the opportunity to submit additional written testimony and evidence before I make a decision. If I continue the hearing, we can come back and do this again at a later date. Whether or not the hearing is continued or the record is held open for any other purpose, state law requires that I hold the record open for an additional week for the applicant alone to submit a final written argument without any new evidence. The applicant can waive that right if they choose, but if anybody else wants me to hold the record open for any other purpose, or if anybody wants me to continue the hearing, you must make that request before the close of the hearing today. Also, my decision must comply with state law that requires that I issue a final written decision within 120 days after the application was filed. So there's some limit to how long I can hold the record open or continue the hearing. When you testify, please begin by stating your name and your full mailing address. Please spell your last name so I get it right. And if you represent someone else, please say so. There is no arbitrary limit to the length of time you can testify, but testimony should be relevant to the applicable approval criteria as set out in the staff report. Also, please don't repeat testimony offered by yourself or earlier witnesses. Repeating your testimony doesn't make your case any stronger. It's not a popularity contest. Whether everybody loves it or everybody hates it is not an issue I get to consider. The only issue before me is whether the application does or does not comply with the applicable approval criteria. That concludes my introduction. Staff will talk about the technical issues of how you can indicate whether you want, if you want to testify, and other Zoom-related issues. Ms. Fields.
Good morning. This public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, have both audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature. Attendees on PC and iPad, you have a raise hand button on the Zoom bar. And that may be at the top or the bottom of your screen, depending on your device. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all the participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide testimony. Be sure to provide your name and mailing address when you begin. Once you have provided your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of this hearing and you wish to submit additional written testimony, email that written testimony to myself, Joy Fields, at jfields@clackamas.us, or mail it to the Clackamas County Planning and Zoning Division at 150 Beaver Creek Road, Oregon City, Oregon 97045. The staff contact email address is also available on the webpage where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer written decision. If you do not wish to testify but would like to receive the decision, you must provide your email or standard mailing address. You can email the staff contact at jfields@clackamas.us, or you can enter your email and standard mailing address in the Zoom chat function during the hearing. That concludes my description of the process.
Okay. You want to go ahead and proceed with your presentation?
So we are here today to talk about Z0218-24. It is very similar to a previous land use application, Z0367-23. However, it is substantially different in that the average number of guests is proposed to be 75, and the parking was reduced to only include 125 parking spots. With those changes, the applicant was able to resubmit their proposal to have a home occupation to host events at 10611 Southeast 232nd Avenue. The proposal, in addition to having the 75 average participant number, includes a maximum of 40 events per year. And those events are proposed through April or between April and October, with the 7,444 square foot tent being used as storage or for overwintering plants during the winter months between November and April. The property is located near the intersection of Southeast Borges Road and Southeast 232nd Avenue. It's approximately 4 acres in size. It is zoned exclusive farm use, and it's east of Happy Valley. The aerial image shows the tent that is proposed to be the location of the events. And the applicant is proposing to use this as a permanent structure, not as a tent as defined in section 806 of our zoning code that's used for temporary use. This is a large structure that is proposed to be permanent, even though it is a tent-like material. All the structures are located on tax lot 101 of tax map 13E 34B. There is a residence as well as a barn that is also a shop. The property is served by well and septic. It is in a groundwater limited area. The applicant in the proposal does not propose to use the groundwater from the well to serve the events. However, they are in a groundwater limited area and would need to show evidence of another water source if they get approval to have the event here, to ensure that the groundwater is sufficient for the use, or that they have a contract for outside water source. They're not proposing to use the septic. They're proposing to use porta potties. They do have a trash receptacle, a waste receptacle structure near the top of the property closer to the house. It was unclear from the proposal whether that will be used for the events or whether that is for personal use only. There is a stream on the southwest corner of the property that is also a regulated habitat conservation area. The site plan provided shows the turnaround for fire access as well as the parking. It also shows that the applicant is proposing a line of trees along the western property boundary to provide a buffer from the neighboring farm. At the time of the staff report, we had not received public comments. However, as of this hearing, we have received several comments in opposition to this home occupation to host events. They include opposition due to farm and forest impacts, parking, noise, as well as a concern about the material in the application being inaccurate. The Transportation and Engineering Division has provided comments. They are Exhibit 7. They address traffic. The criteria that we're looking at for this home occupation to host events is the underlying zoning district that is zoned exclusive farm use and is subject to section 401 of the zoning code. 806, which is the zoning section that regulates and creates the parameters for home occupations to host events. That includes the hours of operation, the number of participants, the noise limits, and other items that home occupations to host events have to comply with. Section 1005 is relevant because of the outdoor lighting that is proposed to serve the events. Section 1006 is relevant particularly because of the surface water management, and with the habitat conservation area, there's concern about stormwater pollution entering the stream on the southwest from impervious surface. There's also street lights that are required because they're inside the urban growth boundary, even though it's zoned exclusive farm use. And then there's roads and connectivity that are addressed in Exhibit 7 from the Transportation and Engineering Division. There's signs. The applicant is proposing to use a temporary sign for the event. The parking and loading, the applicant is proposing enough parking spaces to serve the guests that are anticipated to attend, including the up to 300 guests. And trash and recycling, because of the potential impact to neighboring farms, would need to be addressed and would need to be cleaned up and taken care of appropriately after each of the events. I noted that some or all of the testimony that has been received since the staff report was issued, and that there's concern about the distances in the application not being correct. And so I wanted to provide aerial images with an estimate of the distances and some excerpts from the testimony that we have received to date. So this shows the house on the property to the south is approximately 287 feet. That is an approximation, and it's from the center of the tent to the center of the house. The house to the north is about 335 feet from the center of the tent. There was testimony submitted that indicates that the home occupation to host events has had a negative impact on the farming of the area, including access to the fields by having visitors blocking the roads, as well as event participants parking in the fields and damaging plants. The other home to the east is about 455 feet, and the one to I just switched my directions. I apologize. The one to the west is approximately 455 feet. The one to the east is approximately 604 feet. The recommendation from staff is to deny the application. The tent is not customarily accessory to farming. Looking at the material the tent is made out of, staff do not anticipate enough light getting through it to support the plants during the winter. The applicant indicated that the plants would be by the windows. The conversation with a neighboring farmer that staff had this week indicates that during the winter, when the sun is low, it will not get into the windows on the side of the tent sufficient for providing the light that overwintering plants need. And once the sun is up in the sky, the material on the top of the tent won't let in enough light. So there's a concern about the use of the tent for overwintering plants. And the other testimony received indicates that the tent is not similar to a storage unit. And so staff found in the staff report that it's not customarily accessory. There's also not clear reference to the comprehensive plan policies. The overarching goals of the comp plan were addressed in the application, but the specific policies that this proposal meet was not clear in the application. As noted in the introduction, if people want to submit additional testimony or receive a copy of the hearings officer decision, that can be submitted by mail to the Clackamas County Planning and Zoning Division. That is at 150 Beaver Creek Road. Please put the application number Z0218-24 on any testimony or request for a decision.
Thank you, Ms. Fields.
Yeah.
On page 9 of your staff report, it notes that the 150-day deadline is November 18th. I assume that's a typo because the application, the document included with the application says 120-day deadline is January 30th, 2025. I just want to make sure that is correct.
That was for making the application complete. So when the application was submitted, it was deemed incomplete.
Yes.
And so they have since made it complete. So I apologize if I referenced the wrong date for
Is January, what did they say, 30th, the correct date?
Let me check.
And it's also 120 day because it's in the urban growth boundary. The staff report is 150.
You are correct. It was deemed complete on October 2nd, 2024. So January 30th of 2025 would be the 120-day planning review clock deadline.
Okay. Thank you.
Yes.
Just to correct a minor typo on page 22 of the staff report. It says they proposed 172 spaces.
And they propose 125, yes.
Thank you. That's what I couldn't remember what they had said. Well, these other questions are more for the applicant. It appears they're proposing. I'm not sure what is the parking spaces proposed to be surfaced with. Is it grass or gravel? Because the code says inside the urban growth boundary it has to be hard surfaced unless a permeable surface is required for surface water management. Is a permeable surface required in this case?
They have not submitted a stormwater management plan to the Transportation Engineering Division, so I did not see one, but for concern regarding the habitat conservation area, planning staff would recommend a permeable surface.
Okay.
To facilitate more infiltration of the stormwater. However, it's not required at this time because we haven't seen their stormwater proposal.
Okay. I'm trying to think how I could phrase it if I approved it. If we get to that, how I could phrase a condition that, what was it? Hard surface is required unless they submit a stormwater plan that shows it's required for that, which seems reasonable. So it seems likely it would be, but I'll deal with that when we get to it. And I'm just putting that in my note. Um, on page 27 of the staff report, it says, full paragraph, the last line says the accessory structure of the tent doesn't appear to be normally associated with either the farm and forest use or the residential use. Is residential use relevant? Because residential is not a permitted use in EFU, and the standard requires that it be normally associated with uses permitted in the applicable zoning district.
However, 806 says we consider residential uses as well.
For impacts, but not for types
Because
of business.
there is a primary home on the property,
Uh-huh.
in the planning and zoning division, we tend to look at primary homes being a primary use because it was established prior to the exclusive farm use restrictions. However, it is zoned exclusive farm use. And so that is a good point.
Okay. On page 31, it appears to allow the use of portable toilets, but the septic and online wastewater program indicated that it can't be used because there's a permanent residence, or excuse me, the tent is a permanent structure.
That was what they indicated for the last application, Z0367-24. And the code requires that any on-site wastewater management meets the state requirements that is managed by the septic and on-site wastewater program of Clackamas County. And I'm not an expert to those state requirements. I don't know if having the use of the tent for the events only occurring between April and October changes that piece. And so they will have to coordinate with the septic and on-site wastewater program to determine if porta potties would be a valid use. Even though the structure is there permanently, if the use of the structure for only half the year, if that would allow the porta potty use. I am not clear on that.
That is something that needs to be decided before I could even consider approving, because if portables are not allowed because it's a permanent tent they're not allowed by the state law or the county septic and on-site wastewater program, then they'd have to use the septic, and there's no evidence that the existing septic is adequate. So I think that has to be resolved one way or another before we can consider approval.
I can reach out to the septic and on-site wastewater program and request clarification
Okay.
on that piece.
Condition 313, I think it's page 34. Yeah, condition 13 on page 34 says the exempt well can be used for commercial purposes of hosting events. That seemed, I didn't think that was allowed. It's not proposed, and I think it should, given the groundwater limited area, it should be prohibited.
In circumstances where there's a home occupation to host a home occupation on a site that involves minimal commercial use, if the water master determines that the use would meet the flow
The
available
exemption
for exempt
criteria.
wells, then they can provide us with that letter. Again, I am not staff to the water master, and I'm not sure what their requirements are. But if a residential well is used for commercial purposes, we want to make sure that it meets the Oregon requirements.
And it seems like that needs to be resolved as well. Either that or change the wording of that condition to get approval from the water master or provide alternative water source. That's the only questions I had for staff. Thank you. The applicant's opportunity, who's going to go first, I guess, on behalf of the applicant? Mr. Woodward or Mr. Serenchuk?
Can you hear me okay, Mr. Turner?
Yes, I can. Thank you.
Okay. Yeah, I'm ready to step in for the moment and get things going. I will note that I
Can we
believe,
get your name and address, et cetera? Then
sure, Charles W. Woodward IV, 44 West 35th Avenue, Eugene, Oregon, 97405. I just want to let everybody know my client is having issues hearing what's going on, and he just texted me that he can't hear anything on his
And
feet.
has he tried logging off and logging back in? That would be.
Let me see. Can you hear
He's
Ivan?
doing that right now.
Yeah.
Well, we can hear him.
Yeah.
We heard him for a second.
And it appears two people are logged in with his link, because there's two Ivan Serenchuk, so that may be an issue as well. I don't know. That's up. I'll ask the county's technical experts.
I saw that as well. Ivan, can you hear us? It looks like he's
He's
trying to
muted
dial
right
in.
now.
Yeah.
And the other one says, well, one says he's muted, the other one says connecting to audio, and I'm not sure if it's him or not. You're
Yeah.
probably seeing the same thing I am.
Correct. Yeah.
Yeah, we'll wait and make sure he's on before we go much further. In the meantime, Mr. Woodward, I understand you're the applicant's attorney. Is that correct?
Yes, sir.
Okay, just want to
Yes, sir.
confirm that. We can see you, Mr. Soranchek. Can you hear us now?
Yes.
Okay,
Okay.
good. Thank you.
Awesome.
Great.
Okay. I just want to start with a couple of things. I've got some answers for you. Unsurprising. I actually had a Zoom meeting with, and I apologize if this is a little scatterbrained. I just want to make sure that I'm touching all the bases. And one that's fresh in my mind, of course, is I had a virtual, well, it was supposed to be a virtual meeting. Turned out we had issues with technology ourselves. So it was a phone call, but I did speak with the septic department earlier today. We had a meeting just prior to this. And so I can answer a couple of things. Number one, portable restrooms are allowed. But as far as whether it meets a plan that would be sufficient to comply with state law, that requires us to develop a plan. And in talking with them, it appears that we will have no problem in being able to come up with a plan that solves things. And so a condition of approval, assuming that it would get approved, a condition of approval saying, that it's required for us to meet that plan approval. It should be no problem, as I understand it from my discussion with them earlier today. So at least as far as that, we can clear that up. The other thing I would say, speaking directly to condition of approval number 13, having to do with the water, we've mentioned previously, we are not going to be using that groundwater from the well, as it is a restricted district. The catering company that will be that is going to provide the catering services for the events, they are going to be handling all the water. And
that's what I understood. So would the applicant be okay with a condition that we prohibiting use of the groundwater well for the events? Okay, that's what I assumed. That makes it easier.
Yes, definitely. And the other thing before I die, well, a couple more little housekeeping notes. As far as the parking surface, you mentioned some issues with the parking surface. We're certainly amenable to doing permeable or impermeable. We realize it needs to be hard packed regardless. All of that to say, the ADA slots will be paved regardless, for many reasons, all great policy reasons for that being the case. And so those specific spots are guaranteed to be paved. Everything else, we're ready to work with them. We obviously have the required setbacks from the stream and everything to help with that. And we don't expect that to be an issue either. And that as a condition of approval also, of course, we're fine with that as well. There was the county spoke about speaking to a farmer related to a farmer in the area related to the building itself. And I find that interesting, number one. And number two, we have a contract with someone, the actual nursery who wants to use it, who finds it, whose evidence, I guess, from the contract itself directly rebuts any of those contentions having to do with light and whether the building is something that would be useful to him in his actual in his business. I will also note that that does not take into account the beekeeper who will also be utilizing the tent during the off season as well, and which is also an agricultural use. And there was no evidence rebutting his stance on that being a great building for his purposes as well. There were some issues, appeal comments that came in related to parking about past events, and I'm going to be straightforward with you. I came in after the last application to represent my client. I can say that regardless of whatever happened in the past, we have addressed that with this particular proposal. That is the one that we are actually addressing with the criteria today. And all the parking, as has been noted, has been provided on site so that there shall be no other issues anywhere else with any of the other property owners or parking on the roads. We obviously realize that that's prohibited and would not allow that from our standpoint. And of course, the recourse for that would be if that did happen outside of our control, that obviously is a county issue that they could take up. And as again, we provided full parking on site for even the maximum number, which we expect to happen rarely, if it ever, on the site. So that should not be an issue at all. As far as the farm and forest impact, we're starting to get into some of the things that I wanted to address specifically. Last little sort of housekeeping item has to do with the waste receptacles. They will not be the ones by the barn. They will not be the ones that exist by the house. We're going to work with the county.
Trash, waste. I'm sorry, I
Yeah.
just septic.
I'm sorry. Yeah, I'm sorry.
No, that's okay.
Thank you.
Make
man.
sure
Yeah,
we're on the same page. I appreciate that.
we're gonna put a bucket
What
by
about the waste
barn.
receptacles again?
Yeah, so the waste and the recycling, we're going to build the enclosure. I worked with the department on other enclosures for other home occupations to host events, and so I'm familiar with exactly what they want, and we'll have no trouble in building that little enclosure next to the barn to be able to handle the waste and recycling and keep it tidy. And of course, obviously, it will be removed. It will be emptied after every event, so that will not be an issue as well, and will also be shielded visually, so there wouldn't be any impact on character or anything to that respect. Getting into the specifics of the issues that the staff had that I think pushed them towards the denial. I have spoken about a couple of the issues about the appeal comments, and we'll dig into them a little bit more. As far as the noise, you will note the staff didn't find an issue with noise. We after the last application that went through that was denied, I believe you wrote that decision, Mr. Turner. I'm not.
I did, yeah.
We took into account some of the issues that you were concerned about, and so we undertook a completely new sound study, much more exhaustive, closing doors of parking cars, and we have notes. I believe it's in Exhibit 13 of our materials to demonstrate that between, and this is again without even the trees coming to full maturity along that border. There was no issues with noise from the sound or from the car doors or anything like that. And so as the staff found that the noise criterion was met, we also agreed that there shouldn't be any issues with noise. Again, I can't speak to anything in the past. All I can speak to is the application that we're looking at presently, and to say that we made sure our proposal will not have those negative impacts on surrounding areas. And then digging into, and I think I mentioned, I covered the issues with the bathrooms. As again, I spoke with the on-site sewage, and I believe we'll be able to work that out, no problem. There was one thing where they mentioned that the agricultural goals of the comprehensive plan were, they had some issues that they didn't believe that maybe we had met
It was the
that.
policies, not goals.
Oh, I'm sorry, you're correct. It's the policies. I have it goals. You're right. I'm getting,
Yeah, that's
don't wanna
okay.
get-
I guess I had the same thing.
yeah, don't,
And
don't.
they definitely said policies, so.
Yes, you're correct. I apologize. So on the first part with respect to this, the staff concluded that the proposed use would not alter the character of the surrounding area in a manner that substantially limits, impairs, or precludes the continued agricultural use of the surrounding properties. So as a sort of lowest bar of this sort of analysis, staff's already found that it won't alter the surrounding area in a substantial way. And then second, as to agricultural use, one of the things that the staff asserts that we strongly disagree with is the staff seems to assert that the property up until 2018 was used for a quote low intensive agricultural use, and they rely upon an aerial photo from 2018. I believe it's on page 7 of the staff report. However, in contrast to this notion of a low intensive agricultural use, it only shows the picture of the property as a lawn. It's grass. There's no rows. There's no obvious or indicia of any sort that it was used for any sort of agricultural use. And I would certainly think that characterizing a lawn as a low intensive agricultural use is perhaps a bit disingenuous. In contrast, if you look in that actual same picture, you can see the property across the road towards the bottom of that picture, and you can see rows of crops very clearly. And so it's very obvious that, for instance, that's an indication of actual agricultural use. You can also look at page 41 of Staff Exhibit 2, for a clear shot of properties and agricultural use. That's a much more zoomed out picture of the area, and you can clearly see the areas that are being farmed and put to agricultural use. Additionally, Exhibit 8, which I believe is page 45 of the staff report, we placed in an aerial photo from 1994, and though it's a little bit grainy, it also shows no rows of plantings. And
It shows
furthermore,
what did the 94 photo show?
the 1994, it's a little bit grainy, but it shows the same thing. It's just a lawn. There's no rows of planting. Or there's no obvious. And I do apologize for the grainy issue, but doggone it, we can yell at Kodak in 94 for their lack of
Things have definitely improved.
Yes. And additionally, on that same issue, when Mr. Saranchuk bought the property, the former owner told him that the property had only been used as a body shop during the last 30 years and that no agricultural use had taken place. So the property, as we have asserted, the property has not been utilized for agricultural use for several decades. However, the utilization of the tent, again, that's part of this proposal, the utilization of the tent during the winter months as proposed will actually bring the property back into some agricultural use. I believe exhibits 9 and 10 are some submissions by the nursery and the beekeeper as to their contracting the tent to be used during those off months, and that's an additional reason why the proposed use is limited to the months it's limited. In addition to it being sort of practical for hosting an event outdoors, it also, as an important part for Mr. Saranchuk, is that it also allows the tent during the winter months to be used in that agricultural use and to be a benefit for the agricultural community in the area. Is very, very big on, actually, contrary to the negative appeal comments, is actively working to reach out to the community to be a resource and to be an actual benefit to the community, both through, an event center and the employment opportunities that come along with that. He's reached out to, I believe it's a rehabilitation center in the area, to be doing landscaping And there's the school, the Montessori school across the street has reached out for using Mr. Saranchuk's property as a evacuation collection site in the events of emergency. So he's working very hard to be actually a big benefit to the community in as many ways as possible. Back to the agricultural, sorry, I got a little wandered off there for a moment. Back to the agricultural side again. Being able to utilize the tent in the winter months for those agricultural purposes also helps to financially support the property's use overall, and to be actually using the land rather than it just being a lawn sitting there while someone's using it as a body shop for 30 years. It's actually beginning to use some of it for agricultural and for business in the area itself. So in our opinion, the evidence both in the record and as I've presented here clearly shows that the agricultural policies of the comprehensive plan are being addressed in a way that is positive, as we're bringing agricultural back to the property when it hasn't had such usage. And I think the last thing that I would like to address as I'm rambling on, the substantiality, the building that's similar to others in the area, I believe it's 80602C, that the event with the occupation will occur in buildings similar to it. There was evidence from a farmer that I addressed them earlier, and that I don't see in the record. Perhaps it was put in after I've looked. So in that respect, it appears that, and it also appears, just as a side note, that the county is assuming that the record will be left open for a period. I assume the open and response and rebuttal, typical 777 or whatever.
That's what I assume, but if somebody needs to request it, I'm assuming you are.
Yeah, well, I'm going to be honest.
Or
I thought that the county requested it when they said that if anybody wants to mail in testimony, they can mail in testimony. So we're fine with that occurring. But they did say that you could mail in testimony. I don't know how you're going to get mailed in testimony that I don't respond
Ms. Fields,
to.
is the county standard to hold the record open automatically?
No.
Okay. One of my other jurisdictions does. That's why I wanted to check.
I thought we needed to hold it open to get clarity from the septic and on-site wastewater program.
I think yes, I think that would be a good, but somebody has to explicitly request it. Is the county explicitly requesting it?
It appears that Mr. Woodward talked to them. If that is suitable to you, then we don't need extra time to get it in writing as an exhibit to the file. If you want it in writing, I can get clarity, but I would
think somebody needs to provide me something in writing if I'm going to rely on those statements.
Then let's hold the record open for that additional clarity on septic and on-site wastewater program for a week.
Thank you. I hate to be nitpicky. I just need somebody express request to hold it open. We can't just do it because I want to.
Absolutely.
At least in theory. Anyway,
I appreciate your attention to detail on that. Back to the building substantially similar. I would call, is it easier for me to share my screen to show you a couple of exhibits that are in there, or is it okay for me to just refer to them? I'm not sure what would be
either one.
Okay. Well, being my notes are on the computer too, and I've got one screen.
If you're going to refer to a particular exhibit, I'm going to try and pull it up as you do so.
Exhibit 17.
Okay.
Which I believe
I only have through 7. Did that come in recently?
That would be an exhibit 2A from the staff.
Okay. Oops. And is that exhibit 17, I assume, is an attachment to your letter?
Yes, sir. And
there we go.
It is.
In my decision, when I refer to these exhibits to your letter, I'm going to refer to them as attachments.
That's fine.
To distinguish between the county's exhibits and your exhibits.
Okay.
Anyway, I'm at exhibit 17 of 2A. Go ahead.
Okay, and that's page 30 of that, and you'll see in that
31 on my screen, but yeah.
31 on your screen.
It says 31 on the printed on that photo as well. It's blue buildings. blue and white with white roofs and.
Oh, it's the next one. It's page 32.
Oops. Oh, it's also exhibit.
Yeah,
17.
there's
Okay.
multiple pages on exhibit 17.
Yeah,
Page 3
okay.
of exhibit 17.
So page 32. Okay, got it.
Yes. So you'll notice
Looking at the right one.
that I think we can all agree that these are certainly greenhouses. And I think you can very clearly see that the tops of the greenhouses have been covered with a tarp. And
Mhm.
as you can see from the leaves on the trees and on some of the plants there, this is the winter months. And so it is quite common for greenhouses in the winter months to have the light on top at least. And this is, I believe this is just outside of Damascus. I can get the exact address if you would like. So I've got pictures of greenhouses that are completely impermeable to light on the top. And in fact, if you look at the second one next to the wire frame, it appears that even the front is quite shielded and maybe even the back is quite shielded from trees. And yet I don't think anybody would disagree that this is necessarily a greenhouse. So from our
Aren't those,
standpoint,
is that impervious to light though, those covers? Because I've seen them, just generally driving around the area. I see greenhouses that have those for portions of the year. I don't know exactly when.
correct. And a lot of some of them use them for light deprivation, for forcing fruiting and things at different times, so you can get fresher tomatoes earlier in the year and get them to
Sure,
market.
that makes
Things like
sense.
that.
But is there
and so-
evidence that these are impervious to light?
I think it's quite clear they're impervious to light. You can see
Okay.
through the ends, and you cannot see through the top. If you zoom in, you can see that they're actually tarps that have been draped over the top. You can see the lines of the different levels. In fact, that one zooming in, it looks like it's got 2 layers of plastic.
The one that's next to the wire frame.
Yes, it looks like you can see along that edge, it looks like there's 2 layers. There's a smaller layer underneath it, the tag is line hanging out, and then there's a black line where there's an even thicker portion up top. So again, it's pretty common for greenhouses, even during the winter, much like we're suggesting in the area, to be impervious to light. And as far as what is it substantially similar to a greenhouse in this respect? Our answer is 100%. Obviously, it's substantially similar to a building associated with agriculture in the area. Aside from that, you will also notice there's not really any light getting in on the sides. And again, that one greenhouse certainly doesn't appear to be getting light on either end. And yet that is definitely a building associated with those uses in the area. So add to that the actual notion of, is storage. The beekeeper specifically is delighted to have a building of this specific type to be able to store his bees, as it fits a profile that is not easy to come by with other buildings. And so it offers the benefit, much like a storage building, of protection from wind and rain, and yet also much like the greenhouse still has some minimal light getting through, and again still being able to deal with the temperature differential of having a covered top versus a lighted top. And the more important thing is not light coming through the top in the winter, it's more for the temperature gradient. I'm be happy to let the nursery, the gentleman that's contracting for the nursery for the overwinter months to more directly address that if necessary. But it's our contention that certainly this is, while it is certainly similar to the other buildings in the area. And it is distinctly, I mean, you can parse definitions all you want, but the fact of the matter is that we've got 2 agricultural businesses that are contracting to use the building. And as far as evidence, I'm not sure you can get much better than that, than the professionals themselves actually
Is
said.
there a contract with the beekeeper? I saw one with the nursery. I don't recall seeing one with the beekeeper.
I believe it was Exhibit 10.
Okay.
Which was page 48 of the staff report, which was in Exhibit 2 of the staff submissions, and it was page 48.
Okay.
And then, doggone it, I think I've darn near run my mouth enough at this point. Do you have any questions for me at this point, Mr. Turner?
Yeah. on page 39 of the application, I think it might be that same one your letter. Looks like it.
Was it 2A or the supplemental?
Yes, it is Exhibit 2A.
Okay, and you're looking,
Let me, oops. Trying to talk and control my mouse at the same time, and it's not working. It was just a photo, and I didn't know what it was. And now I'm
Oh.
trying to find it because it doesn't seem to be, I think I misquoted the page.
okay.
There's just a piece of, looks like electrical equipment that's round and I didn't.
Oh, page 30, is it page 36?
There you go. 36, yes.
Okay, that's showing the top of the fixtures that are hanging there. On page
Okay.
5.
On the previous page, those chandeliers.
Yes, sir. I wanted to make sure that I identified the exact light so that we'd have that information. And I
Okay,
believe
that's what I didn't have a clue what that was.
I
I read all
I'm
those
sorry.
labels. It didn't make any sense. Thank you.
Yeah, absolutely. And I believe, yeah, that was just to be able to be quite honest,
Sure.
it was for my information as well, to be able to locate the exact what exact light was being used so that I could provide more information there in the narrative.
The application notes that they recently planted trees, and there's
Mhm.
existing mature trees screening the homes to the north, and that opaque fencing. There is opaque fencing on the west boundary. I just wondered if the applicant wants to submit photos of those showing that. So I'm not sure what type of opaque fencing. Is it solid? Is it or it's alternate sides? I don't know. I just wanted to know if they.
Yeah, I'm thought that we had thought if you look at it's page 42 of that
same
same
one?
exhibit,
Okay.
if you that is looking to the west, and you can see it's chain link with the plastic slats.
Okay, so we are looking west there, and those are
Yes.
the trees that the arborvitae there, or whatever those evergreens are along the fence. Those are the recently
Correct.
planted trees.
Yes.
Okay, thank you.
Yes. And I think that's the only picture of a fence. We can certainly get a more close-up view if you would like.
That gives me an idea of I just didn't realize what direction we're looking there, and
Okay. Yeah.
thank you.
Standard 6-foot. Are they?
Yeah.
Yeah,
Okay.
standard 6-foot with the opaque slats and everything.
The narrative has some conflicting statements about the hours of operation. Page 2 says events will be held on weekends between 2 and 9, 2 p.m. to 9 p.m., one event per day. Page 11 of the narrative, it's page 14 of the application, the PDF. The home occupation will operate within the following sound parameters from 7 a.m. till 10 p.m. on Friday and Saturday, 9 p.m. on all other days. So there's a conflict there.
No, I apologize if it reads that way. One is just mentioning that those are the hours of the sound ordinance and that we would necessarily be within those. The events, the earlier statement about when the events would actually occur is related to the events and when they actually occur. They fit within that. I apologize for not making that clear. I was just making sure that it was clear that our expected and proposed hours of usage will fall within that statutory limitation.
Is the applicant okay with the condition limiting it to weekends between 2 p.m. and 9 p.m.?
Yes, that's fine.
Okay. And weekends, is that Friday, Saturday,
weekends also including Friday. Am I correct?
That's fine. Just ask it. Friday, Saturday, Sunday.
Yeah, that'd be great.
That's okay, great. There isn't much evidence in the record regarding existing farming practices in the area. And the prior order noted that there was noise, dust, odors, other impacts may interfere with weddings and other events from farming, and that neighbors testified that the applicant allegedly threatened a neighboring farmer who was planting fields during an event on the site. There's very little about what farming operations are occurring in the area, when they're occurring, etc. The application also notes that the operations fall outside of normal business hours for farming, and I don't think there are such a thing based on my experience with prior uh, applying the standard in other jurisdictions and as well as here, that farmers testify that they operate during the harvest season 24/7 sometimes. So I just wondered if you could expand on that.
Well, the harvest season would be towards the fall, so the primary areas of actual usage would be during
Well,
the
haying is
summer.
generally in the summer, in my experience, growing up bucking hay.
Okay,
Um,
well, I'll just say this, I'm not, what impacts are expected? I mean, we're willing to deal with, number one,
The
I believe.
problem is if dust, noise, etc.,
Mhm.
from farming
Yeah.
impacts the use, and then the attendees or the operator objects, physically trespasses, enters that was the testimony from the prior hearing, and
Well, I'm going to, well, a couple things. Number one, I can't completely address that. I wasn't there for that particular
Mhm.
testimony, so I can't actually address the veracity of that. All I can say is this proposed use, and my understanding from speaking with my client is that that was not actually a correct characterization with what might have happened in any interactions with his neighbors. He does mention that he has some issues with a particular neighbor who seems quite not quite in his side with everything, and rather disturbing comments that are being placed about. And so I think there's maybe a particular issue with someone local, but as far as everyone else, my client has, and even so, my client has only treated that person with respect and has not had any sort of physical confrontation. So the notion of a physical confrontation, of course, that is not something that I would ever advise, and I believe that's not something that my client would ever engage in. And so, as far as that's also, maybe a defamation of character and impugning his character and his obvious dedication to being a benefit to the community, I think you can certainly rebut some of those suppositions with some of the evidence that we've presented today. Certainly, if there is dust or things that pop up, that's something that we would have to deal with being in the EFU, and we expect that if there are those sorts of issues that occur, we would have to deal with them accordingly, and that the proper recourse for dealing with that, of course, would not be something that would be illegal or confrontational or something that would be negative to the community. That's certainly not, that doesn't make any sense from our standpoint of being a valuable member of the community. So as far as the farm's impact on our proposed use, we don't see that as anything that's going to be an issue. I believe the farm to the direct east, I believe, is doing crops and they're not doing hay. Things like that. Of course, you can't predict whether that farm will forever be crops and not be hay. But again, if there's an issue with the farming, that's the risk that my client is willing to take as far as impacts on his particular operation. And as far as how to deal with them, there's a way to do it, whether it's scheduling, certainly can work with the local farmers if they're going to be haying in certain spots, and again, being a benefit to the community and working in harmony. There's certainly ways to do this that would eliminate any of those issues in a way that is
I don't
very.
know that benefits to the community are relevant to the approval criteria. The issue is whether it will be significantly impact or significantly change farm and forest practices and that have no adverse impacts. I don't get a balance. It's good for it here,
Okay.
but it's bad here, and then it works out.
Okay, well,
it's
I would point to the staff's conclusion that that the proposal will not substantially limit impact or impair those uses in the area.
Yeah, but that's the finding I have to make, and I want to make sure
No.
there's sufficient support for that finding. So
I
I'm
appreciate that.
throwing out my concerns is all, or my question.
I understand. Again, I appreciate the concern. The traffic has come back and said that the traffic won't be an issue.
Mhm.
By limiting the noise levels to the 70 decibel level, as we did in the sound design and as proposed, that should eliminate any of our issues with noise across. And again, if there's issues from somebody else coming our way, that's a risk we're willing to take and we will deal with appropriately. It's certainly
Okay.
not something that we will be impacting other areas in a way that would be negative at all. We have specifically tried to, again, by limiting it to just a few days instead of across the weeks, limiting it primarily towards the evening hours. Again, I understand your concern with it being 24, some farmers saying they work during harvest during 24/7. But again, that's a risk that we're willing to take, and it's not something that we believe any of our activities will in any way harm. We're not going onto their fields. We're not going to be in any way disrupting their ability to conduct their activities on their property. We certainly don't think that our specific proposal in any way trumps their obvious quiet or otherwise and reasonable land uses on their properties in any way, shape, or form. So,
Okay, I just again you've addressed this, but I just want to throw out all my questions, concerns. That
absolutely.
Your narrative says the hours of operation are focused on avoiding time periods where conflict with nearby farming activities might occur. Like there and outside of normal business hours for farming, there really is no evidence in the record what normal business hours for farming are in this area and what
Well, I appreciate that. I think my statement in that regard was relying on sort of the common understanding of farmers getting up at the crack of dawn and beginning their work quite early and for the vast.
but there's no evidence that that occurs here.
I
In
appreciate.
Washington County, I'm also hearing the officer in Washington County that again, that's their standard, doesn't apply here, but state law does, that can't significantly change farm or increase the cost of farm and forest practices. There, the county requires a radius around the site variable depending on the scope of the use, and that the existing farming activities within that area be identified specifically and what practices they conduct. They're tilling, they're spraying, aerial spraying, they're haying, whatever. So it's that county requires very specific information. So that's kind of at the back of my mind as I'm reviewing this, that there isn't really any evidence other than the photographs showing row crops of what specific farming activities are occurring on properties around this use that could be impacted.
In
I
that
understand your
case,
argument that you're not generating traffic noise, lights, et cetera, that might impact that, but given that may be adequate, I don't know. I just want to throw out my thoughts.
understood. I appreciate it, and I think we will use our time during the open record period. In
Okay.
fact, if that's
That would
apparently
be
something
great.
that will be useful, I might even request that we extend that the first open record period to 14 days instead of 7. We got plenty
I'm
of
happy to
time.
do that if the applicant's willing to extend the clock for that purpose. I think we're fine, but just in case.
Yeah, we've got, as I understand it, your decision is not due till January. We've got plenty of time, and we'd be willing to waive that if necessary. We want to get the right information in and make sure we're above board on everything. We're not trying to in any
I
way do
appreciate that.
anything, slide anything by or like that. We want to be very in concert with working with the county and with everyone.
Thank you. So that's the only question. The last of, oh, yeah, I did ask. Okay. That was the last of my questions on the farming impacts. If you want to move on. Oh, wait, you've completed. Noise was my second question.
Okay.
The sound, you provided your sound study. Was the tent fully enclosed, all the doors shut when this study was done? And what happens when the doors are open? Because I understand there's a patio on the back, the west end of the tent. Hang on just a second. I'm going to get back to my hearing screen. I had the photos in front of me. So I guess the first question is, were all the doors shut during that test? And what happens when they're open? Does that affect the test, the noise test?
I believe they were closed, but I'm not sure. Mr. Ivan, Mr. Sranchuk, can you address that?
Yeah, so we
Can you identify yourself for the record, Mr. Saranchuk?
yeah, my name is Ivan, last name is Sranchuk, Saranchuk.
Thank you.
Residents of 10611 Southeast 232nd Avenue.
Thanks, sir.
Yeah, so we tried it actually both ways and it didn't really affect much. This is sound noise, and again, to be exact, when we did the full volume of the decibels inside the tent, yes, the doors are shut. Again, it's just a tent. So in order to open entire tent, I mean, we haven't done that, but we did open some section. It didn't really make any much difference because it's just a PVC material, so it doesn't really make much
Right.
difference.
Does, when you say open sections, I assume you could take the walls off, so to speak.
Correct.
Okay.
Yeah. It's a tent, so you can actually remove 15 feet sections. I mean, you can.
Okay, that's what I understood. I assumed, but I appreciate the clarification. Let me finish my note real quick. If
And then
if the tent walls are gone, it seems like that could have some impact. I understand the applicant's testimony that it's just a PVC material, but it is a physical barrier.
Correct.
Which could
I
significantly impact if you take the walls down, because the summer it's hot,
yes,
let airflow, that could significantly increase the noise, and I want to make sure the noise study is adequate to show that.
understood. Ivan, so when people are accessing the tent, they're coming through, there's like a door, or do you have to remove a particular section to let them in?
There is a when you come from the front, yeah, you remove the section, or so what we've been doing, we would just open up like one of the sections up front where people come in. So yeah, that's that section been removed when I did the noise sound. So I mean the section was removed completely.
So
So
during
it
Was
was
removed, I'm
removed.
sorry. It was removed?
Yes,
Okay.
but now during operation, all the walls are intact and nothing's lifted up, correct?
correct.
Okay. So
You're okay with the condition that the walls remain in place during events?
Yeah.
Okay. That addresses that issue directly.
yeah, sorry we weren't clear on that, Mr. Turner.
No, that's okay. I want to nail these down.
I understand.
What about the patio? Obviously, I assume it's intended for guests to access that during events. How do they get through? Is there a door? Do you pull the walls apart?
No, there's a walkways around the facility so they can go on the back.
Do they go out the front and walk
Yeah.
around? There's
Yes.
there's no access between the west end of the tent and the patio?
Correct.
Okay.
And I believe we have a picture of that pathway in Exhibit 2A. In fact, I believe it's the picture with the fence that I mentioned to you earlier.
Yeah.
You can see that pathway that goes around along that side.
Yeah. It's kind of a gravel path.
Yes.
Okay. Yeah. The access to the patio is not a significant concern as the noise. Okay. What about people on the patio talking, because it's relatively close proximity to the west boundary? Does it,
Close to the west boundary, but it's nowhere near the house. The house is
but
quite.
the noise standards apply at the boundary, not at the house?
I'm pretty sure that that a few people talking right there, we definitely would want to keep it down.
Talking, laughing, singing, it's, people are enjoying themselves at a wedding or other event.
Yeah, I
There
have
can't be some significant.
I plant the trees right on the property line, so that eliminates the noise levels. I put
Again, that was one of my other questions is, do you have any evidence that those how much sound mitigation those trees and that fence provide? Right now, they're fairly limited. There's a lot of space between them, and even when they're bigger, it's my understanding from other noise analyses that there's not as much noise mitigation from vegetation as I assumed. So can you provide some evidence about how much noise mitigation they will provide, or that activities on the patio I can't tell exactly how big it is for right now. I'm sure I could calculate it if I needed to, but if a lot of people are on the patio singing, talking, laughing, whatever they're doing, celebrating, could that exceed the noise standard at the west boundary of the site, which is relatively close? It's
Well,
something you can address during the open record.
along those lines, what level, what type of evidence? I mean, do we get 12 people to sit there and talk? And I mean, I want to make sure that
I'm assuming you might be able to find something online that this is the noise level that would be produced by a group of people at this distance, and you could calculate from that. If
Okay.
there's, what you provide is up to you, but I'd like to know
okay, we'll get
what
something
you've
in there.
got.
Gotcha. We've
If
got
it's something
we'll
I
get
want to make sure is considered.
no worries.
The speaker location and direction in the test is the other issue. If the speakers are, get my directions right here, at the east end of the tent pointed west, is going to be different than if they're at the west end of the tent pointed east. I have never really considered it, but it seems like there's noise coming out the back of the speakers as well as the front. Most of it's going front forward, but if the speaker location could affect things. I didn't see, it says that a karaoke machine was used with 2 speakers, I think. But that events may use other things, the DJ or whatever, and will have their own equipment.
As far the important part with the sound level is the sound pressure level. So it doesn't matter whether you have speaker or 30 speakers. If you get to your decibel level,
I agree. The number isn't relevant. It's the location of and the direction they're pointed.
So we're pretty hard on from our standpoint. We're not letting them go above 70 no matter what, and we want them to be set up in that particular position. Now, with respect to, you mentioned speakers being directional and non-directional. I have a degree in music and played in bands all my life, so I'm going to offer up this little bit. Number one, treble is very directional. If you've ever gone to a concert and stood in front of the guitar amp, then your ears were fried because of the directionality of the treble frequencies, and that is going straight across to where, so that it's towards the west is how we have it set up in there. And so the sound readings along that western line are with the worst, quote unquote, worst amount of frequencies for transmission.
When you did your test, that's what the speakers were aimed that way?
Yes, sir.
Okay. And where were they located in the tent?
I believe we have it noted on the specific on the actual exhibit 13. It would be on 2A of the it would be in 2A of the staff exhibits that they put in there. And where is it? Doggone it. I thought we had it actually marked on the sound pressure map, but I'm looking and I can't find the darn map that showed all the points.
I didn't see that.
Yeah,
there we go. Page 29, PDF page 29 of Exhibit 2A. It looks like your
there it is. Doggone it. The O.
I don't see speakers though.
The sound source, where it says sound source at 70 decibel with the O.
Okay. That's roughly where the speaker was?
Yes. And doggone it, I apologize. I thought I'd made the legend in green on that left-hand side. I thought I'd mentioned that the amp at sound source spot. I meant to put an O there, so I apologize. That's a typo.
Okay, that you explained it. Exhibit 2A.
Yes.
Page 29. The O is speaker location.
And that way the worst frequencies are shooting into the tent with the closed walls and not out the front door. That was our thinking on that. Sure.
But the tent's 113 feet long. It's the eastern third. If a DJ puts speakers at the west end, how's that going to affect your noise study?
We're not letting them put it at the opposite end.
Okay, I thought you said the events will vary the speaker location and numbers.
No. The action, whether it's a karaoke machine or other speakers may vary. The location will not. We don't
Oh,
want,
okay. That helps a lot.
sorry, we specifically don't want any of those high directional frequencies going out that door. That way we
Okay.
have
Yeah,
the
that
benefit of
was
the
my
buffers.
biggest concern is where they're going to be and if they can.
Understood. Absolutely.
And you're okay with a condition requiring
Oh,
that
what,
they,
yeah, yeah, that's the way we want it as well as operators. We don't want,
uh, can I say the eastern third of the tent?
sure.
Okay. Um, and you also said that you're going to limit them to 70 decibels max.
Absolutely.
You're okay with the condition?
Yep. People need to be able to talk to each other, doggone it.
Yeah, sure.
We don't want to blow them out.
Okay. I'm just looking at my note here. It's probably not an issue, but I just want to ask the notes the use of a generator for the indoor light fixtures for power. Was that considered in the noise study, or is there evidence of the noise generated by that? Again, something you could address during the open record.
I'll address it during the open record. My understanding is he bought a generator that's very quiet for that.
Yeah, I assume it's the manufacturer has a
Yeah. Yeah, we'll get that
noise.
information.
Yeah, okay.
Absolutely.
And that's that. Okay, I think that's it for noise. Just going through my notes. I think that was it. Thank you. Thank you,
Okay.
Mr. Woodward, Mr. Stranchek. Anything further from the applicant at this point?
No, doggone it. I think we covered quite a bit. So I
Okay,
think we're
thank
set
you.
for the moment. Thank you.
Thank you. Is there anybody else who'd like to testify in support of this application? If so, please click on the raise your hand button now. And I'm pausing to give everybody a chance to find said raise your hand button, and I'm not seeing anybody. Okay, who'd like to go first to testify in opposition or with questions or concern? Please click on the raise your hand button. Oh, there we go. Lanai Walker. Looks like you're muted, Ms. Walker. You'll need to unmute yourself.
Hello,
There
can
we
you hear
go.
me now?
Yep.
Okay,
Here.
my name
Can I
is
get your
Lonnie
name and
Walker.
address, please?
My name is Lonnie Walker.
Lonnie, sorry.
WALKER. My address is 10779 Southeast 232nd Avenue. I live just to the south of Mr. Saranchuk. And I am here to vehemently oppose this request. Since Mr. Saranchuk moved into this neighborhood, he has caused nothing but issues. The very first meeting I had with him, he threatened to kill me. He has threatened several times, not only me, but other people. He has a severe rage issue.
Okay, Ms. Walker, I understand there's some conflicts with the applicant. The issue is what they needs to relate to this project proposal.
The effect this has on me specifically, I'm a cancer patient. I'm dying of cancer. I have been bedridden for months and months at a time. And Mr. Saranchuk has done everything he can to annoy and irritate us with this venue. I have submitted videos and pictures of how loud the noise level is, how close they're parking to my property. And he even had a helicopter land right next to us, which was rather jarring. He has done nothing but continuously lie to everybody, the neighbors, the county. He keeps saying that this is not a wedding venue. he's been doing this illegally, and that
What he's done in the past is not what I have to consider. I have to consider what he's proposing with this application. He's proposing to change it and address some of these issues. So that's what I have to consider is what he's proposing now. I understand there's some
All right.
significant impacts from the prior operation. But before, let me ask real quick, you said you submitted some videos. Did you submit them for this this new application? I haven't seen what came in this morning yet, so I'll get that before I make my decision. I will review all that. I just wanted to make sure.
yes, and one of the videos is regarding the noise. I'm standing on my back porch and can clearly hear every word that's being sung from his place. For the amended project summary, he says that he has a distinct interest in operating a business and utilizing the land in a manner that is a direct benefit to the community, including beginning to use the property in the off-season for agricultural purposes. This is flat out false. He has never had the interest of the community in mind. He has done nothing but harass his neighbors to get what he wants. Also, the land has been used for agricultural purposes in recent history by the prior owner.
Do you have any evidence of that?
Pardon?
Do you have any evidence of that, photos, or what kind of ag use the prior owners conducting?
I've lived here 20 years, and he had cows on the land at one point.
The prior owner did?
Yes.
Okay. Do you know when, roughly? Like,
Oh, probably 16 years ago, maybe.
okay.
Where he says that the nearest dwelling south of him is 1,000 feet and has no dwelling on it. I'm 200 feet from him.
I'm assuming 200 feet from the property line?
From the tent,
From the tent, okay.
but probably maybe 70 feet from the property line.
Okay. Your residence is.
Right.
Thanks.
I'm trying to gather my thoughts here and look at my notes.
No problem.
The impact on my property and my family has deliberately been left out. And I'm the one most impacted by his events.
I understand.
And after his application was denied the last time, it was the first time in over 3 years I've been able to have my grandchildren here without having to worry.
About what?
About Mr. Saranchuk's temper.
Okay.
Having to listen to music blasting all day long. I can't open my windows. I can't enjoy my own yard. His guests get upset about the landlord plowing the property back here. We had bottles thrown at us. His guests throw trash into my yard. He called me directly at one point and told me that he had bought this property and he was kicking me out of my home I've lived in for 20 years, which was a lie. He placed a generator against the fence and let it run continuously just for the purpose of annoying me. This past summer, when he was not holding events, we had a beautiful, peaceful neighborhood again. That's what we all live here for. And we have the right to live on our property in peace and quiet and not hearing car doors slamming, horns honking, people screaming, drunks, you know. it's just-
Mrs. Walker, as far as the noise, the issue before me is whether it meets the decibel standard. I think it's 60 decibel, like I have to look. The decibel standard in the code, which was adopted by the Board of Commissioners.
Right.
Those
no way.
noises may still be audible, but if it meets the decibel standard adopted by the board, that's the standard I have to apply.
You'll
I
have to listen to the
understand that-
video I submitted.
Yeah, I will review that definitely. I just want to clarify that
Yeah.
what my review is limited to.
Okay. I think that's all I want to say. I'm just,
Thank you, Ms. Walker. I appreciate
Tired
your
of it.
testimony.
thank you.
If you'll click on the raise your hand button as well, so your hand goes down. Does anybody else want to say anything about this application? Please click. There we go. Andrea Hauk. I hope I'm pronouncing it right. And you're muted. You'll need to, there we go.
Yes, my name is Andrea Hauk. That's Houck, and I live at 22941 Southeast Yellowhammer Street, Damascus, Oregon. And I am the representative of the Northeast part of the Damascus CPO. I was involved in the last the last hearing. My concern is that there's some things that were said that are not accurate, in that I believe Mr. Woodward said that only one neighbor had any issue with Mr. Saranchuk's property, and that is not true. It is multiple neighbors, and I have gotten a multitude of calls, and the sheriff has been called numerous times to that property because of conflicts with neighbors and Mr. Saranchuk. At one time, a neighbor was plowing his field, or a farmer was plowing his field while Mr. Saranchuk was holding an event, and it resulted in close to a fist fight, and the sheriff had to be called out. There have been other occasions where automatic rifles have been fired over his property line by him. At one time, while there were people in a field collecting berries that were being fired over the top of them, I don't believe that anybody knew they were there because they were not visible, but it's still a very dangerous situation.
Yeah, the guns thing is not something that they're proposing to do. I don't think it may be illegal. I don't know, but it's not proposed as
it's
part of
legal
this
to
event.
fire
If they're doing it,
right.
it's a law enforcement issue, I think.
Right. So, I mean, that was just how many times law enforcement gets called out there because of
No,
disputes
I
with neighbors.
appreciate that. And
But
if you want,
also, as far as noise, I'm wondering, is he still going to be flying in helicopters or not? Is that part of his plan, or is that something he's willing to not do?
I would be predisposed to, unless the applicant strongly objects, I'd impose a condition prohibiting that, because there's no evidence that it meets the noise standards.
No, and it's very disturbing to
Oh,
neighbors.
sure.
There's also been, I've also been notified that, and I believe a neighbor testified last time, that there's been problems with, in the summer, incentives, like lit lanterns being released that then have landed.
Floating lanterns with fire candles or
that
whatever.
have then landed in the woods and the dry fields around his property. There is a level of negligence that I feel would need to be corrected before this would be a benefit to the neighborhood. Everything is built and done and then looked for permission or zoning for it when there's And, yeah, I just think that there would need to be demonstrated that, all of that would stop. Because
Okay.
those behaviors have been so prevalent for years.
Thank you, Ms. Let me finish my note. I can't talk and write at the same time. If you want to submit copies of any police reports to support your testimony, I think that would be helpful. You
Okay.
could do that during the open record. Thank you, ma'am.
Thank you. Have a good day.
You too. Is there anybody else who'd like to say anything about this application who haven't had a chance to? Please click on the raise your hand button. Ms. Fields, how do they do that if they're on the phone again, just in case somebody's looking for it and not getting it? There's several people on the phone.
*9.
*9. Okay, thank you. So if anybody wants on the phone wants to raise their hand, they can hit *9. I see Mr. Srenchek has his hand up. We'll get back to you in a minute. But I'm not seeing anybody else from the public. So back to the staff. Any response from staff?
Mr. Turner?
Yeah.
If I might add, I hate to interrupt, but I believe the second Ivan Saranchuk is not Ivan.
Oh, thank you. Thank you.
Somebody, I think it's somebody from the public that also wants to, so I just want to point that out.
Yeah. Okay. Mr. the second Ivan Saranchuk. You'll need to unmute yourself. Okay. And can
Hello,
you give
Your
us your name?
Honor. Hello, attendees. My name is Verily Pechenyuk. My address 12183 Southeast Wiz Road, Damascus, Oregon 97089.
And can you
And,
spell your first and last name for me? Because it's not on my screen.
Yes, it's Vitali. Last
VITA.
name-
I'm sorry. VATI. Excuse me. VITA. What?
LIY.
LIY. Thank you. And what was your last name?
P as in Paul, E as in Edward, C as in Charlie, H as in Henry, E as in Edward, N as in Nancy, Y, UK.
I'm sorry. After the N was what? Vitality
Y,
Pension?
UK.
Y,
Yes,
UK.
Y,
Thank
UK.
you.
Uh-huh.
Thank you. Thank you, sir. Go ahead.
Yeah, I'm actually one of the neighbors in that area in Damascus, you know, and I've been actually in one of the events, and it was, everything was good, beautiful, and good. I'm sorry for my voice. Everything was organized, and I don't know why is other neighbors complaining, but everything was organized. Noise was good. Everything was good. I think you should approve this application. We need venues like that in our community. And we're actually, planning. My daughter's getting married next year, and we're actually planning to, if you're approved this, venue, then we're gonna do the wedding over there. So I don't see any issues, and I don't see any issues with the noise. And I don't know. I think they're just people just jealous, and maybe
Okay.
you should
Thank you,
approve
sir.
this.
Thank you. Anything further from the county? And Mr. Pitchen, there we go. You clicked on the raise your hand button. That's what I was just going to ask. Ms. Fields, anything further from the county?
Nothing further from the county.
Okay.
Thank you.
Mr. Woodward or Mr. Sranchek?
Yeah, I'd like
Any
to
response?
I'd like to respond to a couple of things. Number one, distance to the house. I apologize if I got a measurement wrong on that. I do believe that when I looked at the aerial photo, I did not see her house. There's a quite extensive amount of trees and riparian area in that area of the property, and I just must not have seen her house on the aerial photo that I was trying to make the measurements from on. I think I was using Google Map or something with their little ruler. So certainly take them. I appreciate that the county did some different measurements that are utilizing a tool I think that I don't have access to. So I apologize if there's any mistakes as far as distances. And the helicopter keeps coming up, and the helicopter was a surprise to Mr. Saranchuk and I realize this is in the past, but just to assuage everybody's understanding, That was not supposed to happen, and that is definitely not allowed, in our opinion. We don't know how people thought that that was a wise thing to do in any way, shape, or form. And unfortunately, bizarrely, we've had to make that an explicit part of the contracts. I never thought you'd have to. Anyway, it happened. So now we learned the hard way, I guess. And certainly we don't want that happen. We don't want that happening at all, much less the neighbors. We certainly understand that. As far as any videos or any past issues with noise and things that may have occurred, again, even with people being near these other properties, by putting the parking on site, we should alleviate all that by limiting the noise, keeping the decibels at a lower level. Unfortunately, some of these lessons were learned the hard way. We certainly recognize that. But the present proposal that is actually before you, we believe addresses all of these things. The videos would obviously only be of past issues and things like that. And again, we appreciate all that, and that's part of the reasoning that's gone behind some of our actual the actual details to this particular submission, so that we can make sure that those are addressed in a way that precludes any of that sort of thing occurring again. As far as any of the actual direct issues, I would like to let Mr. Saranchuk address some of the things that were said, as they kind of impugn his character and his credibility. One other thing, the person mentioned that there were cows there 16 years ago. Again, when we spoke to the previous owner, he said it had never been used as that. Maybe there were cows 16 years ago, in which case in 16 years it hasn't been used as agricultural use, and that's being generous in giving credence to unsupported comments. And we have my client can directly speak to having actually spoken with the previous owner about no agricultural use. So as far as those two things, I would like to give Mr. Saranchuk a moment to address some of the things that popped up as far as that's concerned.
Yeah, I want to kind of.
Ms. Strand, take just a moment. Ms. Fields has her hand up. I want to let her go so that you can address anything she says too, Ms. Fields.
In the application, you indicated an average participant number of 75 with up to 300. The only math I was able to find that would make an average of 75 was one event of 300 people and 39 events of up to 70 people.
Mhm.
I wanted to have you guys address that if you were planning on having a different number of participants, so that we could get an accurate understanding of how you get 75 as your average participation.
Well, specifically with that regard to that, the reason we even put 300 on there is the rare event. Obviously, that's what would be allowable by code, and that's in the rare event that could occur. We put everything in place so that could occur. And obviously, it's impossible to predict what would occur. Obviously, that would be a good financial boon for my client were he to get an event of that size. But we would have to balance that with the recognition of we don't want that. We want to make sure that our average is lower, primarily because that is the actual events that we're focused on. We're not focused on the rare event that might occur with 300. We want them smaller. We want to keep them smaller. And so the average is 75. We're looking at, to be quite honest, most events being 50 to 75. And I would presume that I'm not even sure that we would ever get an event that was 300. So if you're asking for us to somehow, I'm not sure.
Well, we could
Trying to
be a
leave a
condition
little.
that you track the number of guests at each event, summarize it, and average it.
Yeah, we're certainly willing to do that. I don't want to. I hesitate to say, well, we're only going to have 300 guests on the third Thursday and the third Friday.
No,
in April.
I understand that, but there has to, if you're going to propose this average, and we're basing the revised application, and therefore you could submit earlier on that. I think there needs to be that needs to be held to that limit.
Sure. We're proposing that limit because we want to hold that limit. That's 100% what we intend to do. And if there's some sort of evidentiary way that we can present that in a way that doesn't unreasonably, handcuff my client to being able to contract freely, we certainly intend on making sure that we don't exceed an average of 75 across any given year. And we're perfectly willing to, we're going to have ledgers, so we'll have evidence of all that. We'd perfectly be willing to compile that or something if that's a reasonable way of showing, providing that evidence.
Would
It's
you
my
be
assumption-
opposed?
Sorry, go ahead, Mr. Fields. Go ahead.
Would you be opposed to a condition of approval of one event up to 300 people and 39 events up to 70? Because that's how you get an average of 75.
Yeah, so
Not being a math major, I'm going to go out
You
on a
can
limb
do
and
that
say
during the open record if you want to do some math.
Okay, because I'm going to, just from a math standpoint, my concern is I just want to make sure that we get you the information you need without being unreasonable. And that to me sounds a little weirdly unreasonable. I mean, maybe Mr. Saranchuk, maybe I'm not had time to speak with my clients. So perhaps, as
Sure.
you mentioned, Mr. Dermott, it'd be best for us to provide some more detailed evidence in the open record period that could deal with that issue, and we'd be more than happy to do so.
Yeah, it's my understanding that these events have to be scheduled a long way out.
Sure. Yeah.
So you've got 70-person events all summer, and then at the end of the summer, two people want to do bigger events. Does that blow your average? That's the concern.
Then we don't let them. 100%.
You'd have to deny that. Refuse to.
Yes.
Yeah, okay.
Absolutely.
As long as you're okay with that, and if you want to propose some condition language that you're more comfortable with, I'll consider that as well. And if the staff wants to propose, you pretty much said what you are proposing is the one of 300 and the rest are 70 or less. But so I'll consider whatever anybody wants to submit.
Yeah, absolutely. And I'll
Appreciate
definitely work with staff to make sure that I get something that they feel comfortable with as well. We,
Okay.
again,
Thank you. Yeah,
just try not to overlock our hands and yet give you everything you want 100%.
I understand.
I appreciate the threading the needle.
Mr. Stranchuk, go ahead.
Uh-oh, it looks like he fell off.
Yeah. Well, wait and see if he comes. I'm sure he'll come back, but if
Yeah, I saw,
there
there
he
he is.
comes. There he comes. It says you're connecting down there. We lost you for a minute. Looks like you're connected again, Mr.
yes, sorry, yeah, it's keep on shutting off for some reason.
That's okay. It
Sorry
happens.
about that. Yeah, I just wanna like repaint my character, because I mean I heard some false accusation towards my image. My background, I worked at the nuclear power plant in refineries, and in order to work there, you have to pass all the psychology tests and make sure your temper is not like what been said. I also been running several different businesses. I was invited in the White House and Washington DC. I mean, being a character like my neighbor tried to paint me.
You've lost your audio. You're muted. You're still muted.
Yeah,
There you go.
Yeah.
You said something about the character the neighbor tried to paint you. That's where we lost.
Yeah, as a negative person. However, like I said, I've been invited in Washington DC for as a Republican Party, and worked at the nuclear power plant. So in order to get in those, you have to qualify to have a everything good with your temper. Anyway, I also run, I have several businesses and provide a lot of jobs for my employees. I have employees that work for me over decades, over 13 years. That's been coming. I have a 3 operational clinic, and we help thousands and thousands of clients and patients. One of the events that we did, it was a cancer survivor lady. That's the actually girl that came on a helicopter. So we did, she was a cancer survivor, female that was getting married. So and they also live nearby in that area. Now as I mentioned, I run several clinics, and we help thousands and thousands of clients. And you can look me up on Google, or you can look me up on a review. So people, thousands and thousands of people talking positive. So I know how to run business in the legal ways. I'm not breaking any laws. I try to do it everything by the book. Been successful for many years in a lot of different businesses. So I just feel bad that I can't get along with this specific neighbor, and I have nothing against it. I learned how to ignore people like this because I mean I deal on a daily basis with the homeless situation in because I have one of the offices in Northeast Portland, and I have people like that come in and trying to threat me, trying to break in my windows and stuff like that, sabotaging my business, and that's what I see here. I mean, we have a lot of neighbors that is actually super positive, and they excited for this to be in this area, because prior to me it was a body shop, some mechanical shop. The property was all filled with like a blackberry, so we cleaned it up. So a lot of neighbors actually excited and happy because I mean it looks good. I invested a lot of money in trying to bring this to a better position than it was, and I mean I don't want those negative things that have been said against me. I mean, there is better ways to check me and see that I'm not that person that has been described here.
Okay.
So I work with a lot of different doctors. I have several doctors working for me. I have
I understand.
a lot of different employees working for me, and none of them can say same thing. I mean,
Okay.
all so I have employees that works for me for, like I mentioned, over 12 years now.
Okay, thank you, Mr. Saranchek. I appreciate it. I wanted to give you the opportunity both ways.
Clear my
Assertions, unsupported assertions are not something on either side. Are not something I'm going to consider. The issue is whether the evidence in the record demonstrates that this can or will meet the approval criteria. So that's where I need to. That's where I'm going to go in my decision.
Appreciate you.
Mr. Woodward, we talked about an open. We are going to hold the open. Excuse me, hold the record open. Generally, what I do, as you noted, is 3 periods. Do you want 2 weeks for the first period and then a week and a week?
Yeah, if you wouldn't mind, I've got there's some things that I'm you know, in addition to.
That's fine with me.
2 weeks, I think, would give us a little bit more time to be able to liaise with the on-site wastewater. I'd love to go ahead and deal with the waste receptacles for those people. Get you everything. You know, local farm use.
The more
all that
I
sort of
have
thing.
from both sides, the more support I have makes my decision easier, regardless of where I go.
Absolutely, we'll flood you with evidence.
Today's the 4th. The 2 weeks is the 28th, which is Thanksgiving, day after Thanksgiving. Do we want to go until Monday, the 2nd of December, the following Monday after
I
Thanksgiving?
would prefer to go to the 2nd of December if possible. Yeah.
Yes.
Yeah. That would.
Okay,
That
good.
would
I
be
figured
good.
you would, but just wanted. So
I
in
appreciate
that case,
that.
I'm going to close the hearing. I'm going to hold the record open for a little over 2 weeks till December 2nd for
Perfect.
anybody to submit any new testimony and evidence. Anything anybody wants to submit has to be physically received by the county by what time is submitted? 4 o'clock. You can submit that via email, snail mail, whatever, as long as it arrives by 4 p.m. on December 2nd. I'll hold it open for an additional week until December 9th for anybody to respond. And the second period is limited to responses to issues raised during the first period. No new issues can be raised in that second period. And then until December 16th for the applicant's final argument. With no new evidence, the applicant can, if they choose, submit that earlier or waive it, just send an email to staff to that effect. And I will issue my decision within roughly 2 weeks after that. Mr. Woodward, I had heard you say you are willing to extend the 120-day clock, and you submit something in writing during that first period to that effect as well.
Yes.
Just for a little more than 14 days, whatever, no, 21 days, whatever that period adds up to, if you just extend the clock by that number of days would be adequate for me.
And so how many days do you, I'd be willing to just, whatever's convenient with you, but is there a particular number of days you want me to waive it for? I just want to be detailed.
Yeah, it's 14, 15, 16, 17, 18 days.
18 days? Okay.
Oh, no, sorry. Another week in there. I can't count either.
Is it, wait, isn't the last, Miss Fields, isn't the last day in January sometime?
Yeah, it is.
So,
I just want to make sure we got plenty of time, I think. But if,
Yeah.
if we're going to hold the record up, and I want to make sure we don't have any issues. I'm
okay,
sure.
do you
I'll
want me, you want me to put it, it's put 25? We're perfectly
Yeah.
willing to throw it in there just to be safe and get it,
Yeah.
get it.
Exactly. Just for
25?
safety. Sure, we'll get it
Okay.
out plenty, but if you'll extend it, that would be great.
Okay, I'll extend it. We'll put in for 25 days.
Okay. Thank you. With that, I'm going to close the hearing. As I said, anything anybody wants to submit has to be physically received by the county by 4 o'clock on the 21st of November, the 9th of December, the 16th of December for the applicant's final argument.
Wait,
Thank you all.
Wait.
Have a good afternoon.
I'm sorry,
Hold
Mr.
on,
Turner,
hold on.
I thought you said
Yeah,
December 2nd.
this December 2nd. I can't read my own writing. That's what happens when I try and, sorry, thank you. December 2nd at 4 p.m. for the first open record period. December 9th at 4 p.m. for responses. December 16th for the final argument. Thank you for clarifying that. So that concludes our hearing.
Absolutely. Thank you, everyone. Have a wonderful day.
Thank you, Anna.